Ladies and gentlemen, good morning, good afternoon, or good evening, wherever you are. It's 9:17 a.m. We are ready to start the 5th Oxford Arbitration Day. My name is Andre Luis Monteiro. I'm a former junior academic visitor at the Commercial Law Center, Harris Manchester College, University of Oxford, and one of the organizers of this event, alongside my dear friends Ana Carolina Dallagnol, Felipe Esperandio, and João Ilhão Moreira. We had two major changes this year. Our loyal audience has probably noticed that we have changed the name of our event. From 2016 to 2019, our event was called Oxford Symposium on Comparative International Commercial Arbitration. Now it is Oxford Arbitration Day. It's easier to say, and it's broader in its scope, as now the event covers not only commercial arbitration, but also investment arbitration. Another obvious difference this year is that we are holding the event remotely, which brings pros and cons. On the one hand, we have been deprived of a very basic human necessity, social interaction. On the other hand, we have the opportunity to reach people all over the world. We have 1,200 people registered for this event across 107 countries. This is really incredible. Of course, the success of an online event hugely depends on technology. As you may know, the motto of the University of Oxford is Dominus Illuminatio Mea, which means the Lord is my light. Today, I would say technology is also our light, and hopefully everything will work fine. Now to the program. The event is comprised of 4 panels. Firstly, we are going to hear from a prestigious group of in-house counsel on their views about arbitration. It's the view of the end user, so very, very important. They are the ones who pay the bill at the end of the day. Then we will experience an insightful discussion about construction arbitration. So you just need to put on your hard hat. Enjoy the discussion. At the second half of the event, start with 2020's trending topic. How do legal systems deal with the effects of pandemics on contracts? English law, French law, Portuguese law, American law, Brazilian law, similar approaches, different approaches, we will soon find out. Our last panel will explore interim measures available in different countries, both those granted by arbitrators and those granted by local courts in support of an arbitration. This panel can help you design the strategy for your case. Don't miss it. Last but certainly not least, the Honorable Charles Brower will tell us some inspiring stories from his career and also give his opinion on complex issues in arbitration. Sounds good to me. Let me finish with the acknowledgements. I want to thank our sponsors, whose support is absolutely essential, needless to say. So, CCBC, the Center for Arbitration and Mediation, Hanscomb Intercontinental, GST, Moraes Leitão, Mayer Brown, Apriliano Advogados, Baraldi Mariani Advogados, Caccione Advogados, Lobo de Riso, Luke Advogados, Marquini Botelho Caselta Advogados, and Rodrigo Mendes Advogados. Special thanks as well to our IT team, led by Lauro Parent, or if you prefer, Lauro Parente. I will finish this welcome address by wishing you an excellent event and inviting Dr. Christine van Zwieden, the director of the Commercial Law Center of the University, to officially open this event. Thank you.
Well, thank you very much, Andre, for that introduction. It is my pleasure, my great pleasure, to welcome you today in my capacity as the Director of the Commercial Law Centre at Harris Manchester College, Oxford, to this exciting event. The Commercial Law Centre is very proud to be associated with this prestigious annual event. I say associated with rather than proud of organising it, because it would be quite wrong for us to claim any credit at all for the organisation of today's magnificent programme. For that, all of the credit must go to Mr. Montero, who originally envisaged this event following his time as a visitor, an academic visitor at Oxford, and who somehow manages to pull off an even more ambitious iteration every year, together with his outstanding team of collaborators. So congratulations to Andre and to all of the team that have worked with him to put together a magnificent program for today. There are, I think, a number of features about this event that make it particularly special from the perspective of the Commercial Law Centre at Oxford. One is that this event has always been designed to bring practitioners, academics, and judges into conversation with each other on pressing issues in the field. This is also a feature of other Commercial Law Centre events that we try to put on and to promote. And I think it reflects our view that it's not possible to understand, let alone to come to critically evaluate any part of commercial law without a deep understanding, a deep, rich understanding of its practice. I think this deep understanding can help us to avoid, for example, promoting a legal innovation that is counterproductive or which offers a cure that is somehow worse than the disease. A deep understanding of commercial practice can also illuminate the functions that are, in fact, in the real world played by law and legal institutions. And it can help us to understand those functions which cannot realistically or credibly be performed by law or legal institutions, or ought not for some other reason to be attempted to be performed by law. And I think it's clear from the illustrious lineup of speakers today that this deep understanding of practice as well as doctrine will be on display throughout today's program. And I think this will enrich the discussion at every turn, as it has in all of the previous versions of this fantastic event. A second feature of this event is its international and comparative focus, both in the choice of topics and in the choice of speakers. I had the privilege of sitting in on the delivery of a seminar earlier this week in Oxford on comparative legal methods. And one of the points made by the seminar leader on that occasion was that comparative research is, he said, essentially an exercise in intellectual humility, in which one discovers that you have, in fact, very few original ideas, and that there is much to be learned from the experiences that have occurred with legal innovation elsewhere around the world. In fact, I have the same realization every time I look at legal historical work, and I'm embarrassed to discover that not only is my posited solution far from novel, but in fact, for a variety of reasons, what I have had in mind was not only tried previously, but failed. There was some evidence it didn't work at all. So when the Commercial Law Centre was founded in Oxford, the twin focal points that we agreed would be used to guide our program of events and projects were, firstly, integration and collaboration with practice, for the reasons I've already given. And secondly, an explicit turn towards jurisdictions that had been understudied in commercial law scholarship, against what I regard as a long history of perhaps excessive focus on the commercial laws of a handful of jurisdictions. Now, of course, we must go further than this. We must push not only into neglected jurisdictions, but also into topics that have not yet attracted sufficient scholarly attention. And my impression is that the law of arbitration, sitting as it does on the boundaries between state-supplied solutions and private ordering, is such a topic in which academics ought to be interested, and in which there remains much scope for further development of the scholarship. So today's program, I think, offers a thoroughly international and comparative take on important questions in the field. And this is a very exciting thing of great promise for academics interested in these areas. We're going to begin today's program with a view from the client, as Andre has said, hearing from senior in-house counsel before turning to 3 more subject-specific panels on complex construction disputes, failure to perform due to pandemics and arbitration, and interim measures in international arbitration. Now, although only the second of these 3 subject-specific panels is focused specifically on COVID-19, my intuition is that in each panel today, we will end up hearing evidence of change and innovation that has been prompted by current conditions, just as we are witnessing dramatic change in other areas of law and in the design of legal institutions in the present crisis. I think having this event now makes it possible for us to capture and share these insights in a real-time way that would not have been possible had this event been postponed until next year. And so I thank Mr. Montero very much for driving this event forward with great ambition, despite the administrative complexities associated with hosting large-scale events online. And I thank in particular the speakers who have been willing to participate so generously to offer their time in what are very challenging conditions for so many of us. I wish you all a very good conference, and it's now my pleasure to hand over to Melanie Riofrio at the Madrid International Arbitration Centre, who's going to chair the first panel, and I very much look forward to the discussion. Over to you, Melanie.
Thank you, Kristen. I want to thank the Commercial Law Centre of Oxford and Oxford International Arbitration Society and the Educa Foundation for the invitation to participate in this 5th Oxford Arbitration Day. And of course, congratulations to Ana Carolina, Andre, Felipe, Joao for the excellent organization. This is amazing. And I've seen that there's a lot of people from different jurisdictions, so congratulations. I'm really glad to have the opportunity to moderate this first roundtable. A lot is said about arbitrators, counsel, and arbitral institution, but we sometimes forget who is the real key player in arbitration, and that is the client. The client is the one submitting his disputes to arbitration, and as Andre mentioned previously, they are the end users. They are the one paying the bills. And the ones who know or who can better appreciate the underlying business interests of the clients are the in-house counsel, the corporate counsel, the head of the legal department. The understanding of the company's values, objectives, and priorities allows them to find a balance between the legal and the business in order to take commercially sound solutions and to ensure that the process meets the company's expectations. Now, this morning we have the opportunity to have with us 4 general counsel of important companies that will help us understanding the client's point of view. Specifically, what are the client's expectations when it comes to arbitration? So let me introduce to you our 4 experts. We have Emir Caluf Filho, who is the legal director of BHP in Brazil, a world-leading resource company with business in the extraction and processing of minerals and oil and gas. Nicolás Costabile, who is managing director of corporate service at IESA in Spain, an international engineering and technology company. Then we have Rodrigo Martini, who is the head of the legal department of the Techint Engineer and Construction in Brazil, a company with business in energy and oil and gas industries, and Ulrich Hagel, who is the global head litigations and general counsel officer at Bombardier Transportation. So as regards the format, we will hold a Q&A session for an hour, and then we will leave 20 to 30 minutes for the panelists to address the audience's questions or comments. But I strongly encourage the audience to send any question or comment during the presentation, and the organizers will pass them to me, and I will be glad to pose them to the panelists. So let's start with the first topic, drafting the arbitration agreement. And I'm going to start with Emir. So Emir, tell me, how often do you include arbitration agreements in your contracts? And is arbitration the preferred choice across industries?
Thank you, Melanie. Good morning, everyone. Congratulations for the event. I think this is a unique opportunity for everybody to be together in such hard times we're living in. So
I think we're having some trouble with Emir. Can you hear me?
yes, I can. Can you hear me?
Yes, now.
Sorry. No, I was saying I'm a big fan of arbitration. Always been. I think we live more challenging times every day, and as we go along, I think as we face more and more complex issues every day, I think arbitration is key to solving those issues, right? I don't think arbitration is for everything. Clearly, we have a lot of barriers on that. Culture barriers, costs. I think it's a very. I've been involved in arbitrations where the cost was really too much, or even in jurisdictions where maybe the costs, the system wouldn't be recognized by the judicial system. So I think we need to have those things in mind. But definitely, whenever I can, I always use arbitration in my contracts, and we need to be careful on not using just standard clauses for everything, and you need to be aware of which situation use certain types of clauses, certain types of institutions, and the number of arbitrators, so on and so forth. So, but definitely, I'm a big fan of arbitration.
What about the rest of the panelists? Is that the case for you too? Please, Ulrich.
Yeah, can I say something to it? First of all, good morning, everyone. At least good morning from Germany. And thank you for inviting me to this event. Second, I would like to add to what Emir just said. Yes, I'm also a fan of arbitration. However, we are a little bit more diversified when it comes to the applicable proceedings. And we at Bombardier, we act in accordance with the following principle. Winning a lawsuit is not the goal. Minimizing risks and maximizing profit, that is our goal. What does that mean? We are looking at the disputes as a business case. So we look into potential outcomes, we look into necessary investments, likelihoods, and so on and so forth. And based on a lot of parameters, we determine which would be the best mechanism to be applied to resolve a dispute. And there are a lot of different interests of the parties when it comes to solving the disputes. And those interests, may it be regarding time, cost, confidentiality, enforceability, they need to be considered in choosing the right one for the case at hand. And we at Bombardier, we have developed a tool to find out the best appropriate mechanism for that. The tool is called Direct Dispute Resolution Comparison Tool, and it is accessible for everybody free of charge in the internet. And maybe later on I can share the link to that. And with a questionnaire, you will be guided to a recommendation for the appropriate dispute resolution mechanism. How do we combine that with a contract? We do have a multi-tier clause in our contracts wherever possible. And the first step always is negotiation. The second one, and that is important, is ADR. It's not a specific mechanism. It says parties have to agree on an ADR mechanism when they fail to come to a settlement. For sure, we need a fallback position, a default position, which is mediation if the parties cannot agree on anything. And the last one then is, and now we come to arbitration, is arbitration as the last resort in there. Thank you.
Yeah, it's great. Actually, it's really interesting because according to the Queen Mary University 2018 survey, 97% of respondents, including the in-house counsel, indicated that international arbitration was their preferred method of dispute resolution. But of course, as you mentioned, Ulrich, there's always other previous alternatives that may come into hand for the parties of negotiation and ADR mechanism. And please, of course, if you can share the direct dispute resolution mechanism comparison, that sounds really interesting for the clients. Is there any further comment? Yes, Nicolas, please.
Hi everyone. Good morning, good evening. Good morning, certainly from Spain, and good evening and good afternoon from the rest of the world. Thanks very much for inviting me to participate in this event. It's congratulations. It's incredible they have pulled this off during these times. So a great effort from everyone. Thank you. I totally agree with Ulrich. I think we also, first of all, Ulrich, it would be great to have your tool you can share with us, because I think it's a great thing that you have developed that in-house. I think that would help all companies here. I also believe multi-tiered dispute resolution clauses are the way to go for in our case. We are an engineering and technology company. It depends, of course, when the type of client that we have as well. But when we are allowed to introduce ourselves, the dispute resolution clause, we always would go for a multi-tiered. We always have a negotiation first, and the last resort is arbitration. I've been a practitioner, external counsel for many years in an arbitration practice. So I regret to say that from the client's perspective, we always try to minimize risk, as Ulrich said, and the approach is the same. We look at disputes as business cases. So I think external counsel needs to understand when advising clients what we want, right? So we want to minimize risk, and arbitration, really, once you get there, it's difficult to get away from arbitration. Of course, there are many ways along the process to end a dispute, but I think negotiation and having a multi-tiered dispute resolution clause is always helpful. What I referred before, that it depends when you are allowed, because sometimes, and I would add this to this point, we operate many times with state entities, right? So public clients. So in those cases, we are not really the private company doesn't have a lot of room to really introduce a dispute mechanism, because you go to a tender and you accept the terms of the tender, and usually in those tenders you have the terms of reference that include the main terms of the contract and dispute resolution clauses within those terms. So it would depend, right? But if we are allowed, and we have room with private companies, of course, to negotiate, we will always go to a multi-tiered dispute resolution clause negotiation. I think, in my experience on being on this side of the table, negotiation is always the best way to go, because you solve most of the disputes through negotiation or a ADR mechanism, as Ulrich mentioned. But then, of course, the last resource, and between litigation and arbitration, we tend to choose arbitration, right? Because of the jurisdictions that we operate in. So also that's a factor to consider, the jurisdictions where the dispute may arise, and then in some jurisdictions, for example in the UK, we would sometimes choose litigation, or other parts of the world. So it varies.
And Rodrigo, I don't know if you have any further comments, sorry.
First of all, good morning to everybody from Brazil. It's an honor to be invited to participate in this panel with such a kind of experts in arbitration. So thank you to the organizers. I do agree with my colleagues. From the Brazilian jurisdiction perspective, I can say that it's especially helpful to count on arbitration, because we have a very big concern about time. When litigation comes, to litigate in courts in Brazil is very complicated, especially in the construction sector. The arbitrations involve a lot of factual information, and to go to courts always result in a decade at least process. So arbitration is a very good option for us, and especially with contracts, public contracts. Taking the words of Nicolas, we are happy that arbitration is now being used here in Brazil for public contracts. So it's good news for us.
And I'm very curious to know, because of course, when you choose multi-tier clauses and when you choose at the end arbitration, it's always based on a business sound decision or legal decision. But are there any emotional factors in an arbitration strategy? Do you think, for example, that an arbitration may simply be started to show the other party that a claimant is serious about a claim in the expectation that it will then be easier to reach a settlement, or that doesn't happen at all? Yes, Ulrich.
Yeah, you're absolutely right. Sometimes starting a proceeding like arbitration or court litigation is necessary to also get the settlement negotiations going. Sometimes you really have to show we are willing to go the next and the final step. And only once the other party has seen that, they come back to the table and try to solve it without it. So sometimes, yes, very often it is not necessary, and we can do the other proceedings beforehand.
Yes, Emir.
No, adding to what Ulrich said, I think I've seen a lot. People in Brazil is very cheap to litigate. So sometimes just put an arbitration clause so you avoid your opponent to go to court and to come to a settlement. Because if you just do the math, sometimes it's really expensive. So what happens is people sometimes just put clauses so they want to avoid litigation, as weird as it may seem.
Yes, I think Nicolas is raising his hand too. Go ahead. So just a second there.
Sorry, I was saying that just a quick note on that. Maybe it's not an emotional reaction, really. It's a calculated one. So it's part of the strategy, right? So you might, I will agree with Ulrich that sometimes you have to go to show, or willing to go to take the next step to show strength. But it depends, really. But it's part of a strategy. And we would like to avoid that, but sometimes it's necessary.
And once you have, once you're negotiating your arbitration clause, which are the preferred seat of arbitrations? You feel free to jump in. Yes.
Okay, so, then I go first. Okay, Amy, go ahead.
No, I just very quick. I think it's very hard to say one preferred seat. I think it's the one you're comfortable with and you know it. Because sometimes we just, I'm going to put, I don't know, London because I think it's pretty, or I'm going to put Paris. I think it's important for you to be comfortable with that and for you to be aware of what that means to your arbitration. So usually, if you're graduating in some country and more comfortable, I think that's your best place to go if it's an arbitration friendly place. But I think for me that's the major criteria. You need to be comfortable and have a minimum understanding of that jurisdiction.
I can just add to it. So first of all, I agree to what Emil just said. But at the end, it is a party's decision. It is not only us to determine which seat and which rules apply, and very often those two go hand in hand. So it is a result of a negotiation as well, and the parties have to agree on the seat and the rules. And I fully agree to the principle. It has to be in an arbitration-friendly country. Very often it needs to be kind of neutral. Not in one of the involved countries. It has to be easily reached, and so on and so forth. So there are plenty of factors, but at the end of the day, you need to agree with the other party on it.
Yeah, definitely. The seat of arbitration is one of the main elements that you have to think a lot when you're drafting your arbitration clause. Another thing that is really important if you have institutional arbitration is the arbitral institution. So what do you look for when you're choosing an institution? Maybe, Rodrigo, you can help us with this question. What do you expect from the institution?
Resuming in one word, I would say experience, reliability. For the global institutions give us reliability on the results. We don't know if you're going to win or lose, but we must assure that the process is well guided. So confidence in the process is very important.
Any other comment on choosing an institution? Yes, Nicolas.
Yes, I agree. I agree with Rodrigo. I think track record of the institution, it's always important. The experience they have, the type of parties and the different nationalities of the parties they have interacted with. But I won't say that, because that wouldn't allow space for any newer arbitral institutions, SIAM, for example. So I think also it's important to look at the people that are running, right, the institution, their backgrounds, whether you have experience with them, interacting with them, not only maybe as arbitrators or in other capacity. So yes, I think the tendency is to go with the more established institutions like ICC, CIA. We have had some experience with Singapore as well. But I would say, and especially for sometimes with international elements, I think those are the preferred ones. But we also have, I think all of my colleagues would have many local arbitrations, right? Not only international arbitrations, and also for those arbitrations, I think the local institutions are very well placed to, and sometimes the costs that go into an international institution for a local arbitration don't make sense, right? So I would, it's an assessment of what type of contract we're dealing with, and where we could foresee the dispute going, right? With direction going, it would be going, so we can determine the institution. But we don't close the doors to any institutions, but we prefer, of course, what Emil said about the one that you feel comfortable with. You always tend to go with the one that you have experience, that you have worked with before, and you have obtained good results. I think that's it.
I think that what you mentioned is really interesting. The fact that you want to know who's working in that institution, and you want to have accessibility to those people that is working on your case. And I think institutions have a very important role in transparency. Let's say, for example, you have to be able to go into the webpage of the institution and see the people that is working on the cases, and see the languages that they speak, the CV, their background. I think that is really important, the accessibility that you have and the possibility to see the information about the institution. Do you think it's important, let's say, for example, there are some institutions that provide a service of scrutiny of the award. Do you think that is important? Do you look at when you're choosing an institution? Maybe, yes, Ulrich.
Yeah, I think the best known institution using that scrutiny is the ICC. And for sure, that is one of the aspects choosing it. As the others said earlier, there are plenty of reasons for choosing an arbitration institute, but scrutiny is definitely one. It is a quality control gate that is in there. It also has downsides. It just takes longer, even though they try to be quick, but usually it takes a bit of time. So yes, we consider it.
So if you have to, and this is the question regarding the time, what do you consider a good timing would be for a scrutiny of an award as a user? Ulrich. Sorry.
Well, it's difficult to say because the cases are so different. And if you have a very complex case, then it can take a bit longer, but just a rule of thumb, not more than 3 months in there. And just to put that into perspective, how long do our typical arbitrations last? We usually have no arbitration or almost no arbitration shorter than 2 years. 5 years is the rule, and it goes up to 10 years. And then 3 months is not a lot compared to it, but sometimes we do have very short proceedings as well. We had a perfect case where we settled or where we got the award even within 12 months there, and then 3 months is a lot adding to it. So it really depends on the case and the duration of the overall case. There is no specific rule or one rule fitting all cases.
And now that we have our institution, we go to the more interesting part, which is choosing an arbitrator. Let's say that the dispute has arisen, and now we have to choose an arbitrator. We all know that arbitration is only as good as the arbitrator. So a careful selection of arbitrator is key for a successful outcome of our proceeding. So I would ask Emil, how do you choose your arbitrators?
Well, I think this is, if not the most important, one of the most important steps of an arbitration, of a successful arbitration. Arbitrators today is a trend. A lot of people say, I am an arbitrator. For me, nobody is. You are an arbitrator for a certain period of time. So, but I think given the specialities of that we see and all the proceedings and all the cases, I think one of the major factors for me is first ethics. So I need to be sure that that person has integrity and will play along the rules and won't be favoring one party or another with undue attitudes or things. So this is key, even if it looks like basic rules, but sometimes people just forget about that. So I think that's key, rule number one for me. On second place, I think it's important to see the culture of the arbitrator. Sometimes and I've been through arbitrations where specific traits of the culture could define a case. So if you're not aware, if you're not familiar with that, it's very hard for you to understand that and to evaluate that. So that's a very powerful, I think, tool. And I usually like to get involved myself in choosing arbitrators together with law firms. I think you need to understand how that fits your case. And again, I think the market itself is self-regulated, right? Because if you're trying to be an arbitrator and you're not doing a good job for whatever reason it is, probably the market will expel you from that market. So I think it's very important to look at the track record of the arbitrator and evaluate what he has done or she has done in the past, so you can have a better sense of if you're doing the right choice or not. But definitely we need to be even more rigorous with arbitrators when it comes to ethics, because if you're litigating in courts, you always have a chance to appeal, right, to a superior court or the Supreme Court. And in arbitration, it's a final decision. So you really need to be sure that you're choosing the right person and an ethic person and somebody. And finally, not least important, but I think it's also important, the technical knowledge that is applicable to your case. And sometimes it depends a lot. I've been to arbitrations where the arbitrator was not even a lawyer, was an engineer. It worked well because the case was very technical. So I think that's something else we need to take in consideration, technical knowledge, and that's one of the advantages from litigating courts versus arbitration. When you go to arbitration, you can have that available to you to have somebody that knows what you're talking about.
Yeah, it's really interesting the fact that you were mentioning that the track record is important. Reputation for an arbitrator is really an important asset. But how do you know, like taking into account that commercial arbitration, most of commercial arbitrations are confidential, how do you know about this track record? Where do you get the information about an arbitrator?
I think law firms know, and everybody knows. The market talks about it, and you can be sure if you move from one arbitration to the other, you know who the players are in the market. You don't need to know specific what was their decision or what cases they were, but people who usually get invited over and over and over again to be arbitrators, if they're not ethic enough or good enough, they won't get other chances. So I think that's a natural selection, and if you are in the market, you definitely know.
Yeah, it's interesting again that you say if you are in the market, you definitely know, which brings me actually to this presumption or idea that if you're not in the market in arbitration, if you're a newcomer, if this is, let's say for example, I'm a counsel and I received my first arbitration. I don't know anything about arbitration. I don't know anything about arbitrators. There's an asymmetric information there. Where do I get the information about those arbitrators? I don't know if you have experience. Nicolas, please go ahead. You're muted.
I'm not going to start with your last question. I think you have to rely on the law firms, really. If you're a newcomer and you have no experience and your company has no experience with arbitration or with previous arbitrators, you have to rely on them. Though you have to choose the right law firm that has experience with arbitration, depending on, of course, on the jurisdiction and the type of arbitration you're dealing with. But in many cases, your law firm or your company or someone at your company would have had experience with arbitration, so you can ask around you. But I don't know how institutions could provide more information about their track record, because I agree with everything Amir said. We are looking for all those qualities in arbitrators. Arbitrators are the ones that we look for. So it is difficult if you don't ask around and you don't have previous experience with those arbitrators to get information on them. I would like to underline that the technical aspect of disputes becomes very relevant. So all of what Amir said is very important, and it's key. I think it's the basis. Ethics, of course, we would not go with someone that we've heard or its reputation. It's said that it's not ethical, is not an ethical professional, but technical issues are very important, because we sometimes, depending on the type of company that you are working in, you deal with disputes that are very, very technical, and you have to understand the different parties involved in the dispute, so how the contract works, how the dynamics of the project work. So if they don't know, if they don't have really on the ground experience and they're very close, they might miss something that you wanna transmit to the panel or to the arbitrator that is very important, because it's key. It might be key to the decision of the case. So we will tend to go for, depending on which area we are, the type of case, whether it's technology or it's engineering. Someone maybe, if it has legal background, that's great, but we are willing also to go with technical people that are engineers or software engineers, that they know how this type of cases work, projects work.
Yes, definitely. speciality is something that that is really important when you're choosing an arbitrator. What about availability? Ulrich, I don't know if you take this into account, because sometimes you can find arbitrators that are experts in a specific subject, that have a great reputation, that you know that are excellent, that they will do an excellent job, but they have so many cases that they're probably not available, and maybe your case is going to take a little more time. Do you take that into account when choosing an arbitrator?
Absolutely, we do. And this is definitely one of the criteria. And talking about it, we have a matrix developed which has all the criteria, the selection criteria, in order to profile the potential arbitrator. That is subject matter expertise, the law background, culture, gender, age, availability, all that kind of factors, a lot of that. And then we brainstorm with our external counsel on potential candidates. And then we really evaluate each and every candidate against the profile. And that is very interesting to do. And then we come to conclusions. Then we contact them for conflict checks and availability checks and all that. So this is how we do it. And I would like to answer to another question you raised earlier, in how do you get the track records of people. And usually when we buy something, for example, we book a hotel, we go to the internet portals looking at the recommendations, the star system or whatever it is. And there were plenty of attempts to establish that for arbitrators as well. So judge your judge or something like that. So you can really put points to it. Does that work? Is that a good tool? I don't think so. Because always the party that is losing is giving no credits, and the other one is very happy on it. So it is biased anyway. Always the recommendations are subjective. But here, in this specific case, I don't think it is really applicable. I know that in the UK, there is a law professor working on such kind of transparency and evaluation tool. I don't know what the status is on that one. I'm a bit skeptical. But again, we are in the market, as Emir said earlier. We know the players and we challenge our external counsel. And one point on that as well, I think it was Nicola or Emir saying, well, if you're not in the market, you have to rely on the counsel. Yes, that is true, definitely. But if you are in the market, and we usually raise the question, who would you recommend? And then we get usually the famous names. And we always ask the external counsel, why do you recommend this one for our specific case? What is your reasoning? And then the answers are usually perfect reputation, blah, blah, blah. I've worked with him and so on and so forth. And we say, but have you checked it against our case? Is that really fitting to our case? And then we come into a real good discussion. And then we come back to our profiling system. But that is only for the professionals there. Somebody who is not in the market and has not a litigation department or anything like that, they have to rely on the external counsel.
And what about diversity? A last question on arbitrators. And I would love to hear Rodrigo's point of view, because I know you have policies on diversity. Is diversity something you take into account when choosing an arbitrator?
Sure. I'd like to begin taking Ulrich's point to say that availability for us is crucial, and it's important to have availability not only of time, but availability to listen, to really understand the case. Because sometimes when you have a very experienced arbitrator, completely busy with job, with other cases, you have a question of time, and you have a question about his or her availability to listen, to really understand, to go deeper into evidence. So it's very important for us in this scenario. Diversity relates to newcomers. No? We have been discussing the issue because it allows new arbitrators to come to the market. And us as clients, I believe that we have a very important role in this issue, by discussing with external law firms the names, the profiles, and counting on this specific issue nowadays. It's clearly a hot topic on arbitration too, how to choose the arbitrator.
And what about the other panelists? Is diversity something you take into account? Whenever you, let's say, for example, in SIAM, in the Madrid International Arbitration Center, what we do to nominate arbitrators is that we prepare some lists, and then we give this list of candidates to the parties. And even when when we try to include as many professional and very good women as arbitrator, at the end, it's the party's call. And most of the time we will receive the list back, and we'll see that the parties have chosen a man. So I really want to know if you take into account, let's say, for example, gender diversity when you're choosing an arbitrator. Maybe Nicolas or Ulrich?
Yes, I think we try to. So we have, I think, all companies, we have diversity policies, and we try to apply them in our own employees, and also when we are dealing with cases and we are dealing with arbitration, of course. So I think gender, we try to. We don't care, and let me phrase this correctly. We don't really care about the gender of the arbitrator. If it fits the profile to our case, it doesn't matter if it's a woman or a man. So of course we would want to have the options, to have the broad range. So not the list that comes to us to be only men, because there are excellent arbitrators, women arbitrators out there, and we want them, and we know them, and we know that they might be perfect for our case, for example. So we don't take that into account. So it's just the type, the background, how, as Ulrich said, how the profile of that arbitrator fits our case, our specific case. But I think we are happy to see that more and more women, whenever we get lists from institutions, they're equal, really. Some, in most cases, are 50-50. Also, it depends sometimes on availability and other factors, but when possible, I think it's great to see that more and more women are coming to our lists.
And let me go to yes, Ulrich, you were going to say something?
Yeah, I just wanted to add to that. First of all, I agree with Nicolas on on all of his points. But on the other hand, yes, definitely we have diversity on our selection criteria list as well. And diversity is not only gender diversity; it goes in all directions. And what we usually do is we also look at the whole panel that is being chosen. And once we are the respondent, we always look, how does our potential candidate fit to the other proposed arbitrator or selected arbitrator? If we choose or have influence on choosing the chairman, we also look, who are the other ones? And then gender, again, might be an important factor to be considered. So yes, we consider it, but not as a self-purpose, just to demonstrate we have chosen 5 women in the last year or something like that. This is not the right way to do it.
I completely agree with you. I completely agree with you. For a last question on arbitrators and COVID, as you know, arbitration has had to adapt to the new situation raised by COVID, and many times we have virtual hearings instead of physical ones. How important, given the new COVID times, how important is that the arbitrator is familiarized with technology? Emir, do you have any experience with virtual hearings or with arbitrators not being familiarized with technology? And do you think this will be a criteria to take into account for the next appointments?
If I may, I think it is critical, technology. I think not only the use, but how do you keep the attention of people when you're talking online, right? So and I've been doing meetings with my team online like for the whole COVID, and something researchers show that hard to keep people paying attention for more than 40 minutes online. So not only I think the arbitrator needs to be familiar with technology, but also how do you as a lawyer, or how do you make people keep paying attention? And that's, I think, maybe you need to be more visual, less lawyerish, more make things more interesting. And I think that's a challenge for everyone, right, in these times. Not only for you when you pick an arbitrator to see if is he or she is familiar with technology, but also when you're doing you're bringing your arguments or doing your part of the proceeding, how do you make that more interesting? So I think that's something we all need to evolve in certain ways.
Yes, please go ahead, Ulrich.
Yeah, I want to add to that. So first of all, yes, we are attending a lot of virtual meetings in the meantime as well. There is a limit to it, especially when it comes to witness hearings, but that's a different story. But yes, for sure, the people have to be able to apply the technology. And I haven't seen anyone that it was incapable to do that. The tools are pretty simple. In the meantime, almost everybody is able to manage that. And sometimes we've even seen that either judges or arbitrators are even supported by the institutions. So they get technical support in the background, which is very useful and helpful. And then coming back to Emir's point, it's not only about technology, it's also about using the virtual tool differently than a court hearing. And also there are a lot of guidelines coming from the institutions, do's and don'ts, and what to do and what not to do. So all of that is very, very helpful.
And maybe Rodrigo and Nicolas, you can tell us about your experiences with arbitrators and technology. Do you have any experience on that?
I don't have an actual arbitration with the short term, but I think that it brings us a very important consequence. We are always discussing about time in arbitration, and I hear a lot of people saying that parties and lawyers write too much. When it comes to interviews and webinars, we must go straight to the point. Taking Emir's words, I think that we have a great benefit from that. No? We need to go straight to the point, put our attention on the main issues, and that helps to have a speed process with the whole issue. No.
And maybe just to finish, Nicolas, any anecdotes on this? Or maybe we can go to the next question, which is cost. And I think you wanted to address this issue. Before we go to our next block of questions, I just want to invite the audience to submit the questions or comments. I will be glad to pose them to the panelists if you wish so. Meanwhile, let's go to costs. So many corporations handle arbitrations in-house, but of course, much more frequently, they use outside counsel. And according to the ICC Commission report on techniques for controlling time and costs in arbitration, the party costs, including lawyers' fees and expenses related to witnesses and expert evidence, represent approximately 80% of the cost of an international arbitration. And the reason I'm asking this question to Nicolas is because actually you have experience both as external and in-house counsel. So how do you set an appropriate fee arrangement with the external counsel?
Yes, I think it's interesting to see both sides of the table on this matter. It's a fun topic because it's about money, so it's controversial as well. But I think so. In any type of fee arrangement, I believe there are two key aspects that both external counsel have to take into account because it's what usually companies look for, right? I think the first one is some common both parties have to be feel comfortable with the fee arrangement, right? Because it's not, if the estimation of the fees are not correct and there have to be fee renegotiations along the way, that might hurt the relationship between counsel and client, maybe loss of trust. So it's not a good thing to have a bad surprise along the way, or some, because of course there are some, you cannot predict everything, so things happen along the way, and our flexibility to deal with those things are good. But that's the first one. I think it's key. And the second one, I think it's very important for clients or companies, certainty. I think all my colleagues would agree on this, that we operate, as Ulrich was mentioning at the beginning, we operate, our job is try to minimize risk and trying to get the most profit to the company. So we want certainty about what an arbitration and any type of proceedings would cost, right? So because we operate under strict budgets usually, so bad surprises along the way or are not good and not welcome, and our budgets are monitored by the finance people. So and they're on top of this all the time. So I think it's important for external counsel to understand how the company works from the inside. So what are our challenges when facing an arbitration and any type of litigation, any type of case? Because it's not our day-to-day business, right? So it's something absolutely extraordinary. It depends on how many arbitrations you have or how many litigations you have, and maybe you're more used to that, but it's not about the business, right? So it's something that takes a lot of time from all the company, in-house counsel, but also other people inside the company. So it's important. But I don't want to extend a lot on this. But of course, when you are on the external counsel side, I think you would prefer an hourly rate fee arrangement, right? Hopefully with no cap. That permits external counsel to feel free to do the job, to do the work, and not to worry about time limits or the time that your team spends on the case. So that's, of course, the ideal scenario for external counsels. I think more and more often companies wouldn't go for that, no cap hourly rate fee arrangements. I think you usually would go for a cap or on any hourly fee arrangements. And related to that, and that's also because what I said because of certainty, right? Because you want to know what the arbitration would cost, right? So because it impacts the finance of the company, so you need to take care of that. You need to be sure of that. So that takes me to my second point. I think I prefer fixed cost, especially, and there are a lot of combinations that you can talk and you can engage with external counsel about that. But fixed cost is really one that I think all in-house counsels tend to prefer. Maybe, and if you can be very precise and maybe set them by procedural phase of the arbitration, so you go along and then you know exactly what you would pay for each procedural phase, right? That's also very helpful, and I think it's welcome that external counsel proposes fee arrangements like those. And I want to introduce a third one that maybe it's a little bit more controversial, which is contingency fees, right? Or success fee arrangements. I think it depends on the jurisdiction. I'm a really big on the company side. I'm quite a big fan of contingent, some mix of contingency arrangement. I think 100% contingency fee arrangements are rare these times, and also it depends on each jurisdiction whether to what extent those are allowed. But I think it's always welcome. As they said, the lawyers, the external counsel has skin in the game, so they are part of they are involved. They have they are invested in the project. In this case, in the case. So that I think that helps. I really would like to know my colleagues' experience on this, because I'm quite a big fan. But it will depend. I think hourly rates with no cap, to summarize it, hourly rates with no cap are, in my view, not the best or the preferred arrangements. Fixed, but by procedural phase are the best. And if you add some type of contingency fees arrangement, that would be great.
And any other different combination that is used by the other members of the panel? Because I understand Nicolas is very, like, your point of view is very conservative, like fixed costs for each procedural phase, always know how much you're gonna be spending, and certainty is key. Any different point of view from the different panel members?
I agree with Nicolas completely. I think hourly rates with no caps, that's out of question for everybody these days. I think companies are more and more, they want to know costs. I've done arbitration only on success fees already, and it's interesting. Oh, I'm back. Sorry.
No, you're back.
It's always I think it's always a challenge, not only for being allowed, but in Brazil recently we had a lot of corruption, especially in courts due to that. So it's something we're being more and more careful about using it. But I totally agree with Nicolas on this.
Any last comment before I go to questions from the audience that I see are summing up? No? Okay. So actually we have, we go back a little bit with a question regarding arbitrator and the information on arbitrator. And the question says, do you think arbitral institutions should publicly disclose more information about arbitrators? For example, number of arbitration, previous cases, or time to decide?
I would love that to happen. I think it would be really useful. Of course, always having in mind the confidentiality factor, so probably not disclosing which cases, and that's sometimes tricky, because if you know that certain person worked in certain case, but I think that's always helpful to know. Maybe one of the downsides of arbitration is that you never know. As we said, you're in the market, so you know, but not through official ways. You don't have some certain data you can look at. So I think that will always be helpful.
I do agree with Amir, and I think that it's really, really helpful to count on more information when discussing the composition of the panel. I think that including the availability of the information in one institution would be a very specific and important issue to consider when drafting the arbitration clause, you know? Because you define at the very beginning of the contract. So to have the scenario that would that you need to face when litigation comes, it's very important.
Yeah, if I may add, from an institution's point of view, actually from the Madrid Arbitration Center, what we do, or we're starting to do with our cases, is that we do publish some information regarding arbitrators. So we publish the cases, anonymized of course, to preserve confidentiality, and we publish the number of the case, but we do publish the name of the arbitrator, how was the arbitrator nominated, and the previous cases that he has. And regarding the time to decide, we also have for each of our cases a table with the procedural steps. So this, I think, it's interesting because it goes with transparency, and it's really helpful for users, I think. Another of the questions that we received from the audience, and it's regarding the arbitrators. It's basically asked, it would be great if the members of the panel could share their thoughts on what do they expect from the arbitrators. So once you're looking for an arbitrator, once you nominate the arbitrator, what do you expect from him?
Maybe I can start. Very often you think you want to have an arbitrator that is voting for your case. Yes, it is good to have an arbitrator that is listening to your arguments and that is helping that your arguments are being heard by the tribunal. That is good, but impartiality is still very important. So I think that is what we are looking for or that is an expectation to the arbitrators.
What about the other members of the panel? Emil, for example, what do you expect from an arbitrator?
I agree with Ulrich. I think we need to expect, of course, always to win, but clearly, I think a fair trial. After all, sometimes you know that your argument's not the best. So a fair trial and ethics, as I said, sometimes it's not about losing for the right reason. Sometimes is that you can't be frustrated because you lost because the arbitrator didn't understood what you were asking for or didn't understood the situation completely. And I think that we face that a lot in courts. Sometimes it's very hard to tell your case to courts due to complexity and a lot of other factors. So in arbitration, on the good side, I think you expect that the arbitrator really understands your case and really is capable of addressing the issues. So, but in summary, a fair trial, I would expect.
Yeah, I definitely agree with you. From the arbitrator's perspective, I would say that when I'm drafting in a word, for example, I'm always thinking about the losing party. And I'm always thinking that the losing party has to read my word and understand and see the motivation behind the decision and know that decision or have the impression that that decision is fair. So this is something that arbitrators should always take into account. And going back to what you were saying, Emil, I can understand the frustration that you might feel when you see that the arbitrators didn't get the arguments correctly. Sometimes you see, I've seen that maybe the parties may be submitting many arguments regarding a specific legal issue, and then you see the award and the arbitrators don't even mention that issue that has been so much discussed during the hearing in all the written submissions. So that must be really, really frustrating. And I think it's really important to transmit, to make the best effort to transmit your position, and that the arbitrator catches that position and finds a reasonable and neutral and sound decision. What about the other members of the panel? Maybe Rodrigo, you can tell us something about what do you expect from your arbitrator?
I do agree with my colleagues, because having all that we have discussed during the panel, background, experience, ethics. If the arbitrators are nominated to the panel, having all these issues considered, I do agree that impartiality is the main thing that you need to have at the end. I do agree.
We have
Eleni, yes.
Yes.
Do you mind me jumping in just a quick note on that? I think also when there's a party appointed arbitrator now, right, and you of course you want for he or she to be impartial, but sometimes you expect that arbitrator it's good at persuasion, right? So because if he or she understands correctly the arguments that you are making, and it's not able to convey them to the rest of to the other two members of the panel, and to persuade them that maybe you have to look at the relevance of those arguments and in the best way possible. You're lacking one of the key elements, right, of any litigation arbitration process, which is persuasion. So I think that's also important. Of course, always within the boundaries of impartiality.
Yes, it's interesting to see what you mentioned, the dynamics in the tribunal, the dynamics that you have between the president and the co-arbitrators, because of course the three of them have to be persuasive during the deliberations, for example. And this is why it's so important to choose wisely your arbitrator when you're choosing the co-arbitrator, and even if you have the opportunity to choose the president of the tribunal. Going back to the cost, I think it's Felipe's question, and I'm going to read it. One of the advantages of arbitration in comparison to court litigation is the ability to tailor the proceeding according to the needs of the case at hand. Have you ever been involved in discussions with your external counsel with the view of reducing the cost of the arbitration? If yes, what procedural measures have you devised to lower the costs? And has the opposing side agreed to implement your procedural measures? Who wants to jump in?
I'll just give a quick. I think that's a tricky question. It's always hard for you as a party to question the cost of the arbitration itself or the arbitrators, because you are always afraid of being stepped in, like in a delicate area. Once we were discussing, I'll just give you an example, a big arbitration meeting. There was a big arbitration. We were like at least 60 people in a room, and the hotel costs and the food costs, it was ridiculously high, ridiculously absurd, I would say. And then we were discussing, totally against the policy of the company, and we were discussing, should we challenge that? Would that be too bad? And then we decided not to. But I think on the other hand, you need to be able to challenge sometimes. It's not because you're going for a trial that you're not challenging anything. I just gave a small thing, but it might, these things happen. And it's always, I think, delicate to touch on this matter, because you're always afraid that if you do something, you might get the arbitrators or the tribunal might not get sympathetic with your cause, and who knows what might happen.
I would like to add to that. I think, yes, we can manage somehow the cost of arbitration. So, for example, in the case management conferences and looking at the sequence of events, then so limitation of submissions and all that kind of stuff, that might help to reduce the cost. I hope you can hear me, because I saw that you were all disappearing.
Yes, we can hear you.
Oh, okay, good. So yes, we can manage somehow the cost together with the tribunal and with the opposing party. That is possible. And sometimes we also see that the arbitrators themselves are cost drivers. And we have seen crazy situations where the arbitrators were even asking for a success fee when we settled the case, and all kind of different stuffs. And also when it comes to the arbitrators going always to the upper limit of ranges that are given, for example, by the ICC. And when you ask them why they are at the upper limit, it's always the same answer. It's a complex case. At the end of the day, they have to decide on 5 questions. Nothing is complex about it. Maybe it's 100 of pages to be read, or thousands, but nothing is complex. But we always end up at the upper end. This is what is annoying us a little bit, and we are fighting, but we always have to keep in mind what Amy said: when to fight, take that fight, how to fight it, and does it make sense at the end of the day?
Yes, I agree. You always have to choose your battles. Rodrigo, any comment on this, or maybe we can go to the next question?
No comments. I do believe that the previous questions raised by our colleagues correct on this?
There's another question about diversity, and this time, of course, another kind of diversity, which is about age. So the question comes from Andre. Do you choose young arbitrators under 45? And is it a good idea to establish different arbitrators' fees depending on the year of experience of the arbitrator?
Don't want to be me again, but I have to say something about this. I'm a big fan of diversity, and I think young people can do an excellent job as long as you have the drive, the motivation, and the right skill set. I think you can be really a good difference. So I'm a big fan. I think sometimes, and here is not if you're young or new. I think it's more of a profile matter. If you have the profile, you can be a great arbitrator. If you're 40 or if you're 60, or doesn't really matter. I think, but I wouldn't discriminate an arbitrator because he or she is young. And I'm not sure if the fees question, depending on the years of arbitrator. This might be tricky as well, because the work, it's the same amount of work, so paying more or less, hard to say. I'm not a big fan of the idea. I think if you're in, you should do the fees of the institution, and that's it.
Well, if you allow me, from an institutional point of view, we are very keen on including newcomers and including young arbitrators. We actually, in our rules, we have a specific criteria taking into account diversity, age, gender, and cultural background. And what we do normally is that whenever we have small cases, we do give some opportunities to people from under 45, because I personally believe that a lot of young people is, with their first appointment, they try to do an excellent job. I remember when I got my first appointment, I was 28 years old, and it was a really, really small case, but I worked it as if it was an exit case, a huge exit case. And at the end, those small cases actually are not that easy, because sometimes it's not with sophisticated parties, and it has so many different complex issues. So it was a lot of work, but I remember working really, really hard for that case. So I really think we have to give opportunities to young people. Now, this is from an arbitrator's point of view and from the institutional point of view, but I would love to hear the client's point of view, because when you appoint people with less experience, at the end, you're taking a risk. So what about that risk? And Ulrich, you were raising your hand. I don't know if that goes with your comment, or.
I think Nicolas was first, but if you don't mind, Nicolas, I just go ahead. So a couple of points. Thank you. A couple of points in that regard. First of all, I also think that small cases are a very good way to introduce newcomers to the scene, and especially younger newcomers, and especially if those are single arbitrators. If we are selecting our arbitrator for a tribunal, and the other two arbitrators are silverbacks, it's very difficult to come up with a newcomer there with a very young arbitrator. You need charisma, you need the standing, you need the reputation. Those are all criteria. But for smaller cases, single arbitrator, we are absolutely open. And sometimes not going to the extreme, but in the middle age, more or less, 45 or whatsoever. You're absolutely right, Melanie. Those people are keen to fight for the case. They are really digging into it. They want to do a very good job to get reputation. And that sometimes is also a risk taking the elder arbitrators. Do they really pay attention to your case? Do they have so many other cases pending at the same time? that is also placing risk on your case. So this is what we are considering, and we are also looking at age as one of the criteria, but not only to the lower end, also to the upper end. Do you really want to have an 80-year-old arbitrator sitting on your panel? That is also something we look at.
It's funny that you mentioned the 80 years old arbitrator, because actually I had one experience with one of the cases. It was an exit case. I was the secretary of the tribunal in that case, and one of the co-arbitrators was more than 80 years old, almost 90 years old, and we remember when the president was drafting the award. We were crossing fingers for him not, this is tetric, but not to die, because he was really, really old. And it was a huge case. It was an enormous time-consuming case. So we were hoping not to lose him before we signed the award. And actually, unfortunately, he passed away 1 month after we issued the award. So this is something you have to take into account too. The age is important. Nicolas, maybe you were going to say something, and then I think Rodrigo wanted to add something.
Yes, just to add to what my colleagues have said, I think we are also, it depends on the case. So we are also willing to appoint young arbitrators if the case fits to that profile, right? So availability is, well, and you said it, Melanie, availability is a key issue. Some of the more experienced and more famous arbitrators don't have the time to really look at your case, and we talked about this. So someone that has that availability and the case, it's an experience, it's a good arbitrator, you know them, they're good professionals, they have a good background, you can perfectly appoint a young arbitrator. I think if of course, I agree with Ulrich, when you have a bigger case and there are very experienced arbitrators on the other hand, it's difficult to appoint a younger one because of experience many times. It would not be balanced. But if the young arbitrator has a good balance between experience and availability and of course skills, I think it's totally. We are open. We're open always to appoint those younger arbitrators.
And what about gravitas? Because here I have another question, an interesting question that says, does age play a role when deciding whether an arbitrator will be persuasive vis-a-vis the other members of the tribunal? And would you step back from appointing a younger or less known arbitrator if the other party had appointed a renowned one?
It's a very good question. From my perspective, I think if I appointed a young arbitrator and he or she had the right capabilities, I wouldn't step back, because I think once you make a choice, you need to consider all the scenarios. So even there's always the risk you can appoint one arbitrator and the other party can appoint a more senior one, or more, I don't know. But if you're really appointing somebody who has knowledge of the case, I don't know, very big technical case, and you're appointing a young arbitrator but knows a lot, or it's a very recognized authority in the area, I think I would keep. I wouldn't change my mind, but it's always challenging. I understand the question, and I think it's always tricky. But that's why it's so important when you do your first assessment on choosing an arbitrator, you need to evaluate all the scenarios possible.
I think, Rodrigo, you were raising your hand. Please go ahead.
Yes, Melanie, I do agree with Amir about this question, and take the previous point. I think that the question may drive us to think that experience is more expensive. So newcomers would receive kind of a less than the more experienced arbitrator. But thinking about diversity, I would like to raise a point. Having in mind that the newcomers may put more energy in your case, as you referred. Diversity is always linked to inclusion. We need to give incentives to this. So my question, my point would be, having in mind that energy put in your case is not an idea to give an extra remuneration, an extra fee to newcomers that put energy in your case to remunerate the effort.
Yeah, definitely. We go now to a different question regarding virtual hearings. So the question is, what are the main issues an arbitral tribunal should pay attention to while conducting virtual hearings to circumvent possible challenges based on due process? Any ideas on that? Well, first of all, have you had experiences with virtual hearings? Is there something commonly used, or was it only during the COVID and the pandemia, but now we get back again to the physical hearings?
I think it's always challenging, as we said before, making people pay attention. And sometimes, especially when you inquire witnesses, when you inquire experts or witness, how do you keep the arbitrators focused on that, or how do we read? Because I think crucial part of doing a hearing is that everybody's together, and then you can really feel whatever the person's saying is true or not. So virtually, I think that's harder. It's not impossible, but it's harder. So I think everybody needs to do an extra effort to try to take that into consideration and try to be more focused on what's going on. And today everything is being virtual, right? But I think it's key again to limit the time you spend on the screen directly. Like if you inquire somebody, if you're doing something, try to make breaks before an hour. I think that's key. And if you are bringing your arguments, as we said before, straight to the point, not wasting time just with lots of arguments that you don't need. Otherwise, you just lose your audience. So I think that's it for me.
Yeah, there's so many. It's interesting what you're saying because actually there's a lot of different aspects that we have to take into account to adapt to virtual hearings. We used to have hearings that sometimes would last 2 weeks from 9 a.m. to 6 p.m. But now it's impossible. You have to take into account, first of all, that if you're in an international arbitration, you will have the tyranny of the time zones. So you may have a party that is in Australia, another party that is in Canada, and tribunal that is in Spain and France and Nigeria. So those time zones, those different time zones would not allow you to have an 8 hour, straight 8 hour hearing. And second of all, what you were mentioning, Emir, is there are some psychological aspects that you have to take into account. It's mainly impossible to retain your attention, to have your attention during more than 5 hours in a virtual environment. First of all, because in a physical hearing, you have the different, you can see that the different body language, and this is really important in persuasion. Whereas in virtual hearing, it becomes more difficult to persuade your arbitrator because of that body language. And of course, there's a lot of different hurdles regarding witness examination, expert examination that you have to take into account. I think the question, going back to the question that was posed regarding the due process, I think we can see it as, for example, if one of the parties want to have a virtual hearing and the other doesn't want to have a virtual hearing, or let's say, for example, that one of the parties is in a country where it has all the capacity to have this virtual hearing, but the other is in another country that has a bad network and doesn't have the same opportunities to connect themselves to the virtual hearings. Has that happened to you in any of your cases, or any case where you agree to have a virtual hearings, you want to have a virtual hearing, but the counterparty doesn't, or the other way around? No.
Well, yes, we do have experience. So we had the situation where I think it was us, we wanted to have the virtual hearing, and it was the opposing party saying, no, there shouldn't be a virtual hearing. And it very much depends on either the rules or the applicable law, if that can be decided by the tribunal, or if that has to be consented by all parties. Very often it has to be consented by all parties, and then we just have to follow the rules, and there is no virtual hearing if one of the parties opposes to it, which I think should be the rule for witness hearings anyway. But besides that, yes, we do have that experience. We also had experiences in arbitration sessions where the arbitrator had difficulties with the network connection. I don't know where he was, in any country house, and a very bad connection, and it always broke. So everybody has to make sure that they have a stable line. And yes, in some countries that's more difficult and it needs to be arranged for, but that all goes into the do's and don'ts for such kind of hearings.
And let me go, well, I'm looking at the time. We still have 5 more minutes. And I would love to hear your point of view on what is arbitration missing from your point of view. Is there anything missing, anything that we might do to improve arbitration for the client?
Well, sorry, I'll be quick. I think first we need to be careful with costs. I think that's the major concern. It's getting more and more expensive every day as we go, because then we have the arbitrators or experts, and then we need to set up the hearings. So I think that's a crucial concern, because to a certain point, why we use arbitration, because it's more cost effective overall than litigating courts, right? But if that met it's close, then I think we need to be mindful of that. And second, I think timing, as Ulrich was saying before, today, at least prior, it was common to see arbitrations which lasted 6 months, a year. And now more and more, I think arbitrations are taking too long. 2, 3 years, 4 years, 5 years. I had never seen with 10, but good to know. So I think those two factors are crucial for us to have in mind, because then you almost are close to going to courts. Of course, there's the whole difference of the knowledge of the arbitrators, but I think for me, these are the two major concerns we need to have in mind.
Yes, Nicolas.
Just a short comment. So I think there's always been a discussion on whether arbitration should be shorter, right? Because we, as many of you said, we used to have long hearings, 2-week hearings. I think going back to the challenges that COVID poses, I would like to underline the good side of COVID, in the sense, in the way that we've seen that there's a way to make things shorter, right? Because we can't afford to spend so many time in front of a laptop looking at things, or a monitor. So it's a challenge, but we can learn that could be it's possible, right? It can be done. So I think this can help to just clarify that discussion, and because everything goes around to be more cost effective, right? And of course, if it's shorter, it's going to be less costly. So I think we can learn from this and try to apply it when things hopefully come back to normal. Hopefully it's soon. We can apply the same logic to be more concise and be more precise, and focus on just the main issues at hand in the case, not to just overextend the arbitrations with no reason.
Ulrich.
I would also like to add to that, and we were talking about time and cost, and yes, we always have to be conscious about time and cost, but we should also be very careful, because arbitration is the last resort, and it takes time to get a proper decision and to have a due course there. We as global players, it takes us quite some time to come up with submissions and to issue briefs, to just look into the case, find the right people, find the right experts, and so on and so forth. That all takes time, and that needs to be considered. And if we are only looking at time and cost, there are other mechanisms that can be chosen, like adjudication, expert determination. There we get the quick and dirty, and very often it's good enough for the parties. But if you need a final and binding decision at the end, we need the quality time in that, and that needs to be respected as well.
Rodrigo, any last comment?
Yes. One important thing, I believe that despite confidentiality is very important on the case, to get more information on previous cases, on cases going on in the industry, would be very helpful in determining the composition of the panel, the expected results, and even the evaluation of the success chance of the case. So if you could get information on previous cases, it would be very helpful in thinking the whole scenario.
Thank you so much. Our time has expired, unfortunately, but I really want to thank the panelists, Rodrigo, Emir, Nicolas, and Ulrich, for this interesting conversation. I just want to remind the audience that we will have now a 15-minute break, and we will restart at 11:15 with the panel on construction arbitration. So thank you very much. Bye.
Thanks, everyone.
Thank you, everyone.
Thank you.
Bye-bye.